Hi everyone. In this video, I will talk about the corporate restructuring, insolvency, liquidation, and winding up about that particular subject. Basically, this is a very important subject in the professional program, and then there are two parts which is associated in this particular subject. Very important, basically in the career of company secretary. And I will briefly take you people through some of the important aspects which is covered in this particular subject. The first important thing which we have to discuss in this particular video is what is this subject is all about. Please note there are two parts in this particular subject. One is corporate restructuring and the second part is related to insolvency and liquidation and winding up related matters. First, let me talk about part 1 where we talk about the corporate restructuring related matters. Kindly note, corporate restructuring is one of the important activity which is going to happen in any corporate form of business. If you take up company form of business, if it concentrates only on the organic growth, definitely the company is not going to survive. Okay, let me first talk about, what is the difference between organic growth and inorganic growth, so that it will be easy for you people to understand, why I'm talking about inorganic growth here. Okay, organic growth is something you will start a company and then, year on year you will double the turnover, triple the turnover, or there will be 10% growth or 20% growth or 30% growth. It will be called as organic growth. I will not be concentrating on anything else other than building my turnover by organically doing my business or extending my business activities. This is called organic growth. That is all old style, Basically, how it is really possible that every year there is a lot of competition which is there in the market. New products will come in, so that to survive in this particular competitive world, if I concentrate only in organic ways of business model, it is very, very difficult. I need to adapt to the changes, basically how the market will ask for. So how do I adapt to the changes? Is by way of acquiring similar lines of businesses, or my company will be acquired by some other companies. All these kinds of restructuring activities are very, very important. What is this restructuring? Restructuring is, I won't work in the same old fashion how I was doing all these days. To cater to the requirement of the need of the hour, I will be adapting myself to the new, whatever requirements which comes up. Take for example, I am into a technology driven industry, and then whenever there is an update to the technology, I will ensure that I collaborate with the new technology by way of entering into a foreign collaboration agreement. This is also a kind of restructuring. Well, it is called as technical restructuring. Next comes the company is indebted, so basically it is having lot of indebtedness in the sense it has taken various bank loans or something like that. Then I am not able to repay that particular loan, but now I need to do a fresh financial arrangement. Then I am approaching another entity which can come forward and take over my entity, or I can approach another bank and then basically like they can take over all my existing loans. This is called debt restructuring. The same way you have capital restructuring also, in the sense like, where existing shareholders will be there in a company, and those existing shareholders will be, exiting the company. New shareholders will be coming forward, or private equity people will come forward and participate in my funding requirements. And venture capitalists may come in, foreign direct investment may be brought in. Like that, there are various opportunities available when it comes to alteration of my share capital. So this is also one of the important activity which we call it capital restructuring, or even it might be called as financial restructuring. So like that, all this kind of restructuring activity, the basic objective is to revamp myself from the old one to the new one, so that it will be accepted by the people and then the industry survives. The basic objectives, the industry has to survive. The second important aspect is inorganic growth. Inorganic growth is by way of acquiring similar lines of businesses. It might be vertical arrangements or it might be horizontal arrangements, wherein my industry grows. So if you look at Reliance, or if you look at Tata's, how many acquisitions they will be doing in a year? They will be taking over a lot of entities. A majority shareholding they will buy, so that their group increases by twofold, threefold, whatever it might be, depending on the aspirations what those entities have. So any entity, if it only concentrate on organic growth, definitely to survive in this competitive world, it is not possible. So this particular subject we will necessarily concentrate on what are the various ways in which inorganic growth options are there to revamp from the old technology or the old way of functioning the business into the new way of functioning business. What and all options available is what we are going to discuss in part 1. This is about the subject. When it comes to part 2, in businesses, insolvencies are common. Insolvency in the sense the company is not in a position to repay its debts. So when the company is not in a position to repay its liabilities, is winding up the only option or closure of the company is the only option? The answer is no. First, the opportunity has to be given for revival. That is called corporate insolvency resolution process, okay, where the opportunity should be given for revival. And at the last option, we need to keep it liquidation and winding up. So if the company is not successful in recovering from the insolvency position, only under those circumstances we have to consider winding up. So winding up is a last resort. Winding up cannot be kept as a first option. So kindly note, this is very, very important. This is what we are going to study in this particular part 2, relating to how the opportunity will be given to resolve from insolvency position, and if the resolution of the insolvency process is not at all happening, under those circumstances the last resort we are going to exercise, that is called winding up. And how the winding up is going to happen, what is the procedure which is associated to that, is what we have to discuss. Now, after listening to all this, next important question comes to your mind: why they have introduced this particular subject in CS Professional? How is it really important to company secretaries? Please note, company secretaries are the people who are involved in each and every aspect of either it might be corporate restructuring or it might be insolvency. When it comes to corporate restructuring, there are various procedural aspects involved, right from planning till execution. So if the company decides to go for acquisition of another entity, then all the preparedness, how many number of meetings are required to be conducted, in addition to that, what and all filings which are required to be done, what and all documents which is required to be prepared, the drafting of the term sheets it might be, or entering into the shareholders or share subscription agreement, amendment of the articles of association and memorandum of association. There are various activities which are required to be carried out when it comes to execution of the decision of the board of directors. It is our role, that is being company secretaries, it is our role to ensure that we have to necessarily implement the actions or the decisions taken by the board of directors. The implementation part is very huge when it comes to corporate restructuring as well as insolvency. When it comes to insolvency, one more opportunity is there for company secretaries to become insolvency professionals. To become insolvency professionals, there is a limited insolvency examination which we can take it up and clear. For that, there are some eligibility criteria. The first eligibility criteria is, first you should be a company secretary, and then you have to write that particular examination conducted by the organizations. Even our institute, you have insolvency, examination. There is a sister concern which is going to conduct, where if we clear that limited insolvency examination, we can even become liquidators. And then valuation also. Please note, in all these aspects, whether it is corporate restructuring, when it comes to liquidation, we will not look at lot of shares related valuation, but company valuation will be there. But when it comes to restructuring activity, where a lot of people will come forward and show interest in taking over the shares of my company, or my business is being taken over by other entity, valuation plays a very important role. The company secretaries has got the opportunity to even become registered valuers. To become registered valuer, again there is an examination which is required to be passed, but before passing that examination, the condition is that you should be a practicing professional. So either CA, CS or CMA, if you clear that other examination also to become registered valuer, you can take up that profession. Please note, in the professional stage, the student should be given the areas of operation the company secretaries have, and based on the exposure and then based on the interest, the possibility is there for a student to decide, this is the career I want to pursue. So if you want to pursue advisory related thing, and then you want to advise the board of directors, and then if you want to be in the implementation field, then definitely you can become a company secretary for a company where all the activities can be taken care of. If you are interested in litigation, resolution of basically corporate disputes, and then basically when it comes to resolution of insolvency related process, and then if you want to act as liquidator, then there is another area of practice where you can take up litigation as your thing. Litigation in the sense like you can appear before National Company Law Tribunal, because in corporate restructuring we will be addressing to the corporate disputes also. It is not like we will be talking about only how to revamp the corporate positions. Okay, so this is about the importance of this particular subject in professional program, and you should be really thorough with it, because it will give you the opportunities in the sense like after you pass this particular examination, what are the options you have in the table. So corporate restructuring, insolvency is also a very good option which is there available to the company secretaries, either a company secretary in practice or he might be a company secretary in employment. So this kind of exposure, since we are the people who have to implement all this, it is really important for us to know. That is the reason why they have introduced this particular subject, CRILW, corporate restructuring, insolvency, liquidation and winding up. Okay. Now let us move on to taking you people through what is the syllabus. Okay, briefly I will talk about the overview of the syllabus. You have two parts. Part 1 is corporate restructuring. Part 2 is insolvency, liquidation and winding up. You have two separate books. Each part is assigned with 50 marks. The totally 100 marks paper. 50 marks is assigned for each part. So if you look at in first part, that is corporate restructuring, if you look at the objective, what is the expectation of the institute, basically it is to provide the expert knowledge in the legal, procedural and practical aspects of corporate restructuring. That is what it says. So here I will be talking about what is expected from the institute. Please note, since we are in the professional program, the expectation of the institute, if you want to see, it will be very clearly mentioned in the objective of the syllabus. Open the study material and on the page syllabus, on top of it, they would have mentioned the objective. So there you will understand what is the expectation of the institute. If you see in part 1, what is the expectation of the institute? I will read it as it is from the syllabus. It says to provide expert knowledge of legal, procedural and practical aspects of corporate restructuring, merger acquisitions, insolvency, liquidation and winding up. This is for part 1. And for part 2, to acquire knowledge of the legal, procedural and practical aspects of insolvency and its resolution. Kindly note here, one thing in common that you can pick it up is the expectation of the institute is expert knowledge. The moment they use this expert knowledge, you people should be really thorough with both conceptual clarity as well as procedural clarity. Okay, if I have to simply talk about what comprises of law, law may be divided into two types, substantive law and procedural law. If you look at what is substantive law is the core procedure, core subject matter. Whether I am allowed to do this particular activity or not. The core subject matter, whether a company can get merged with another company. If you want to see that enabling things, you have specific provisions in Companies Act. So after you decide you want to go for merger, what is the procedure which is required to be followed? That you will find it in the rules. A special resolution has to be passed, a petition has to be filed with NCLT, like that 1, 2, 3, 4, 5, 6 conditions will be there. So all those things, the substantive provisions of law as well as the procedures. So now if I have to talk about in the Companies Act perspective, if you find the act, the entire enactment section wise is important. In addition to that, you have rules also, which is very, very important. And you have notifications, circulars and clarifications. Okay, you have notifications and circulars. Notifications, circulars as well as the, rules followed by case laws are also very important. After taking you people to the overview of the subject, I will talk about the case laws also. How is it important and how is it relevant in this particular subject? So if you look at the part 1, that is corporate restructuring, you have totally 13 chapters. Okay, and then at the end I have given case laws, case studies and practical aspects. This is end of paper 1. It is assigned for 50 marks. Okay, The first chapter talks about, the syllabus flows like this. It is like in the sequential order. What are the types of corporate restructuring? Because corporate restructuring is a broader terminology. It comprises of many things. So what are the types of corporate restructuring is the first topic, because that is where we have to understand the concepts. Conceptual clarity is very, very important. Okay, what is that concept? The key definitions. Because you don't see the terminology mergers and amalgamations in Companies Act. Instead, they used the terminology compromises and arrangement. What is the difference between these two? What constitutes compromise? What constitutes arrangement? Mergers and amalgamations, demergers, slump sale, business sale, joint venture, strategic alliances, disinvestments, financial restructuring, debt restructuring, like that. What are the various options available when it comes to corporate restructuring? The types of corporate restructuring is what we have to study in first chapter. Like that it goes on. Acquisition, like how the acquisition has to happen. If it is a listed company, what is the procedure to be followed for acquisition? What is the planning which is required to be done? That is most important, because we are the people involved in right from advisory, planning and execution. All the three stages, there is an important role the company secretaries has to play. So here even planning and strategy. And then the fourth chapter comes about what is the process of M&A transaction. Because I told you both substantive provisions of law and procedures are very, very important. So planning and strategy followed by execution, that is the process of M&A. And what are the documentation for mergers and acquisitions or mergers and amalgamations? Because we are the people who will be sitting and drafting the scheme of merger and amalgamation along with the lawyers or along with the senior practicing professionals. So we should be really thorough and we should be aware of all this. And the valuation, because when the company is taken over, if somebody shows interest to take over my entity, the first important activity which I need to do is valuation. So what are the types of valuations? How do I need to conduct the valuation? What are the methods available for valuation? You have a separate chapter on that. Chapter 6 talks about that. Then comes you have accounting aspects. Okay, how the accounting has to happen in corporate restructuring. The taxation aspect, the stamp duty aspect of mergers and the corporate restructuring. Now not only income tax point of view, that is stamp duty payments, as well as even now one more important facet is there. You people might have studied in your executive program. You have something called Competition Act of 2002. If two huge entities, in the sense like two big groups or two big entities, which is having substantial market share, if it has to get amalgamated, then we need to analyze one important thing, whether it creates any appreciable adverse effect over competition. So the threshold limits are specified. So if the entities which is getting combined, if the combined assets and combined turnover, if you take it, if they meet the threshold which is being specified in the Competition Act, then in addition to taking approval from National Company Law Tribunal, we need to take the approval from Competition Commission of India also. So that's why you have a separate chapter which talks about that also. Then what are other regulatory approvals? Like take for example, if you are a merchant banker, then SEBI will come in. If you are insurance company, IRDA will pitch in. And then if you are basically like NBFC, then Reserve Bank of India will pitch in. Like that, there are various regulatory authorities approval also required in addition to National Company Law Tribunal. And next comes basically who will appear, the appearances, the practical aspects, because even practicing company secretaries are allowed to appear before the National Company Law Tribunal. And then there is one more important activity, which is chapter 12, which talks about fast track mergers. There are specific class of entities which meets the criteria, they can go for fast track mergers without approaching the National Company Law Tribunal. That is with the approval of 3 officers. One is ROC, other one is official liquidator, and the third one is regional director. There is a possibility that they can go for merger without even approaching the National Company Law Tribunal. Then cross-border mergers. With that, part A concludes. Because nowadays, if you stick on that, I'm going to do only business in India, because in this globalized world, we should have complete international connects. So if there is any cross-border mergers and amalgamations happening, what kinds of approval are required, what kinds of procedure required to be followed, you will find it on the last. Please note here, There are a lot of conceptual understanding required with respect to the differentiation between the cross-border mergers and then amalgamations, and then basically with respect to the other aspects relating to the types of corporate restructuring, what constitutes merger, what constitutes amalgamation. There are various case studies which is being provided. There are case laws also. Case law is the verdict of the court which we have to analyze for the purpose of interpretation of a specific provision. At the same time, you have case studies also, because there are various mergers and acquisitions has happened recently in India. So we need to understand how the approach was, how did they plan, and finally how they were successful. So case studies are also very, very important. And in this particular subject, case laws are the, basically the core matters where wherever it is necessary, you have to study the case laws and then you have to quote it. That is the importance of case laws here. So please note, on each and every topic, if you find cases, if it is giving you clarity on the interpretation as well as the subject matter, quoting it in the examination is very, very important. The same way, when it comes to part B, that is insolvency, liquidation and winding up, you have chapters 14 to 26. Okay, I think it is equally divided. Here also you have cases. Okay, so first it starts with insolvency. Kindly note, now insolvency, they have consolidated and prepared a separate enactment which is called Insolvency and Bankruptcy Code. Earlier, insolvency was a subject matter which was scattered around various enactments including company law. But today you have a consolidated enactment which is Insolvency and Bankruptcy Code. So the overview we have to study. After that, as I told you, winding up is not a last resort. It is not a first activity which is required to be done. Winding up has to be always considered as last resort. But what is the first thing, the option which is required to be taken is giving an opportunity to the companies which is in insolvency position to recover from the insolvency. So to recover from the insolvency situation, opportunity should be given. That is called corporate insolvency resolution process. So CIRP, the corporate insolvency resolution process, is the second important topic which we need to discuss. How exactly the petition is required to be filed, what is the role and functions and duties of insolvency professionals here, what are the resolution strategies, that means to come out of this insolvency situation, what are the options, resolution plans, resolution strategies which can be tabled before the National Company Law Tribunal or before the parties involved, is what also we need to discuss. How the meetings are required to be conducted, because here the parties involved will be the shareholders, creditors, all those people, the meetings associated to that, the preparations which are required to be done. Okay, like that the chapter goes on a basically synchronized manner. And then you have the individual insolvencies, the firm related insolvencies also, not only the company related insolvencies or corporate form of insolvencies, even individual and firm insolvencies, how we need to do it. For that also the separate chapter is being provided. And you have debt recovery, cross-border insolvencies, like that, separately they have given with respect to if there is cross-border insolvency, how this insolvency situations has to be resolved. Debt recovery on surface side, that is you have securitization and reconstruction of financial assets and enforcement of Securities Interest Act. According to this enactment, if a bank non-performing assets, basically how they can recover the non-performing assets, what is the procedure to be followed also, separately it is being given. Finally, if the resolution plan is not successful, then automatically it will come to liquidation. Kindly note, if I have to call about liquidation, it is basically there are two steps involved, winding up and dissolution. I should call liquidation equals winding up plus dissolution. What is winding up? Winding up is the process where the assets will be realized and liabilities will be paid off. Surplus, if any, will be distributed to the shareholders. Now the physical existence of the company is over. That is the job the liquidator will do. Now liquidator can be an insolvency professional can act as a liquidator. What is dissolution? Dissolution is the process where I need to remove the legal existence of the company. okay, by the order of the National Company Law Tribunal, the name which is appearing in the records of the Ministry of Corporate Affairs has to be removed. That is called dissolution. Dissolution liquidator cannot do. Dissolution order can be passed by the National Company Law Tribunal. So this is the difference. Liquidation equals winding up plus dissolution. Legal existence as well as physical existence has to be taken out. How we need to do liquidation? What are the rules associated to that? What is the role of voluntary liquidator? What is the difference between voluntary liquidation and compulsory liquidation? Every detail we need to discuss, and then last 2 chapters is concentrating all that, and then finally you have case laws associated to that. Kindly note, if I have to talk about the importance of case laws, for both part A as well as part B, case laws are very, very important, and then case laws as well as case studies. Okay, so specifically, like, there are various cases under each topic which you need to discuss, and then there are certain important cases which has to be quoted while you write in the examination. Okay, so since we have already discussed about what is expected from the Institute of Company Secretaries of India, because I told you there is the expectation of the institute is expert knowledge. If it says expert knowledge, then definitely you should have thorough understanding of both substantive provisions of law as well as procedures. Subject matter as well as procedures, both I should be thorough with. That is the expectation of the institute. Now the last part which I need to focus on is how a student can approach studying this particular subject. That is very important, because 2 parts are there, and then there is a heavy study material, 26 chapters are there totally. Any person who picks it up, he will feel, oh my goodness, how can I study? Please note, it looks heavy, but if you show interest and then if you study conceptually, it is very easy. Conceptual clarity is very, very important. You need to spend lot of time in understanding the concepts. What is the difference between merger, amalgamation, demerger, acquisition, takeover, like that, various concepts of corporate restructuring. At the same time, when it comes to winding up, insolvency, what is the difference between all this? First, you should have conceptual clarity. You have to spend lot of time on understanding the concepts thoroughly with the help of the case studies. Once you are very clear with the concepts, then you can write the procedures. Kindly note how you have to approach is, one reading of the entire study material you have to do, and after completing that particular reading, when you do the second reading, you have to write a small notes of your own in the form of bullet points, concepts in 2 lines and procedures in the form of bullet points, so that you reduce this particular study material which is there in 2 parts into not more than 100 pages. The notes that you have, it should not be more than 100 pages, which will be talking about brief procedures, so that you can write it in an elaborate form when it comes to examination. So this activity has to be done. If you don't do this particular activity, completing the examinations and then remembering the vast subject is very, very difficult. Okay, so this is how you need to approach the study. If you need any help on this particular subject, there will be a number which will be displayed on the screen. You can WhatsApp, so that Ekcel Academy is always there to support you. Thank you very much.